In California probate, one heir lives in the house and refuses to sell. What can you do? We get into that next. Welcome back to the channel featuring the leading probate real estate team in all of California. I'm Brendan Mohr, Realtor, C.A.R Masters Club Life member, and certified probate trust specialist by the California Association of Realtors.
And hey, I'm Bill Heyman. I am a licensed California professional fiduciary. I'm also a licensed California real estate broker, as well as I am a registered and bonded California legal document assistant specializing in probate and trust work.
Like and subscribe right now. Have a house to sell and looking to avoid the cost and headache of probate, trust administration, or even the petition to determine succession? Those services are included in our real estate listing package with no upfront fee, and sometimes no fee at all. We've helped families across California save thousands in costs and fees, and we may be able to do the same for you. Our contact info is in the About section. Please don't wait. Let's talk today. So you have a house in probate, and one heir is living in the house, and they won't move, they won't sell. There's all sorts of reasons why that can happen. But meanwhile, the rest of the family's stuck, and probate can't move forward, or at least the sale of the house can't move forward, which is very crucial. Now, does that sound familiar to you? This happens all the time, and if you're an heir, here's the truth. No single heir can deny other heirs of their inheritance. Now, let's talk about your options. Bill, what's the big picture on this?
Well, and we've seen this quite a bit. A lot of times what will happen is mom or dad, mom passes away, and maybe a son or daughter's been living with mom for a few years, taking care of her, as she was getting older. And mom passes, and that son or daughter who's been living with them tells the family, hey, I've been paying the mortgage, so the house is mine. Or maybe they say something like, look, mom told me I could have the house. Or sometimes they'll say, look, I put some money into this house and it should go to me. We see that relatively often, and it's a problem. Unless the will specifically says that the house goes to that particular son or daughter, or if it was in a trust, let's say mom had a trust. Well, again, unless the trust says that that house specifically goes to that son or daughter, you got a problem. That son or daughter is not entitled to the house if they don't have it in the will or the trust. So it can be a real problem. There are some options. And Brendan, why don't you get into what some of those options are?
Yeah, let's just say that the family really wants to make this, to accommodate this heir who's living in the house, maybe because they have put a bunch of money into it, that they have been paying the mortgage, maybe they don't have another place to go. Well, the heirs can get together and work out a plan for a buyout. And essentially the one heir living in the house would be able to keep the house, refinance it into their name, or really make a purchase. It'd be basically like a purchase. There's a special kind of purchase for that. Now, the heirs would have to agree on the value, and you'd want to have a professional appraisal, maybe two appraisals, whatever you want to do there. But every heir wants to feel like, or should feel like, that they are getting a fair deal in this. And ideally, you want to work with a real estate professional to run a net sheet for the heir so you know what you're getting into. Now, you can sell the house and split the proceeds. The problem when there's an heir living in the house and won't sell, ultimately that's going to get to a point where the court forces that to happen. And unfortunately, what the heir is actually doing is now devaluing the house. So if a buyout isn't possible and no one wants to stay in the house, that can get the highest value. But if the heir is still living there, they're going to limit showings, most likely, or not care for the house. Or maybe they will, but if they're fighting, they may not. So that is a big problem. So there are some solutions there, but it really involves the court getting involved, or the personal representative evicting their loved one.
Yeah, and that occasionally happens where the personal representative, the administrator, has to go through a formal eviction to get that heir out.
Yeah, it can happen. So, if one heir is stalling the process, if they won't talk, if they're blocking it, well, that's really, it's not legal, it's not fair to the other heirs. So there could be other ways you could do it. A neutral third party, like a mediator, coming in and stepping in and explaining the facts to help get things moving again. You want to avoid having to escalate things to more legal fees.
Yeah.
But as long as that heir understands that they don't have a legal path to deny the other heirs their inheritance, then they may get the idea that, they really need to do something here.
Yeah, and the other thing too that is often lost in the muddy water here is that when mom passes away, that heir that was living with mom, if he or she was never paying any rent, from the date mom passes onward, as long as that heir is living there, they're supposed to pay fair market rent on the house to the estate. And that's often forgotten about by almost everybody. But if push came to shove, theoretically, the administrator could go to court and get an order that the heir living there must pay back rent. If not, it could be deducted from his or her inheritance share. So that's another tool that an administrator could use to try to help get that heir to realize that it's time to move out.
That's such an excellent point, because a lot of times mom or dad's mortgage, their payment was less than what the market rent is. So that is a tool. You're saying to your sibling, hey, you've been paying $1,000 a month for the mortgage. Fair market rent on this house is $3,000. That's not an uncommon scenario.
No, it's not.
So I guess, some things that heirs have to remember, right? An heir has rights, and not more than anybody else. Living in the house doesn't make it their own house.
Right.
You have every right to request your share as an heir, or to ask the property to be sold and bought out fairly.
Yeah. And, in situations like that, when this creeps up, unfortunately, you may end up having to bring an attorney into the picture to get this resolved. And, that is going to be extra costs. So just something to keep in mind.
If you're the one living in the home, just increase that communication. Perhaps you and your heirs can come to a solution, and where everyone feels like it's fair. So give that a shot. So, in this situation, we can help. We work with families across California in these situations all the time, and we help to resolve these standstills, often without anything being escalated to where they're fighting, to where they need to have an attorney involved and all of that.
Yeah, because if you do have to bring an attorney into the picture, which sometimes happens, it is going to be more cost. There's no doubt about that. But, like Brendan said, we've worked in situations like that before, and we try to communicate with the families and the heirs and try to get everybody to be reasonable. But if you can't, you may be forced to bring an attorney in.
Now, if you are the heir who doesn't want to leave, or just remember this, when you get to that point where you're realizing something has to be done here, because that will happen, and the house has to be sold in that case, and you're going to be maybe living there, perhaps, you can't afford to find a place on your own. Hopefully your family is going to help you with this. There's options out there. It takes a while for Section 8 and that kind of thing, but please work out with your family that sort of solution. But when it comes to selling the house, please help to make it as presentable as possible, because you're only hurting your own inheritance when you're not allowing the house to be shown or to present cleanly and those kinds of things. So you're hurting yourself if you don't do that.
That's true.
Anything you'd like to add?
I don't think so. I think that's pretty good.
Okay, well, great. Well, please drop us a follow, like the video, reach out to us if you have any questions, especially if you're selling a house in probate in California.